And
No,
I
but the
just to go
question
back-
is, can you harmonize the two statutes? I keep going back to that point. Look at your Iraq question, okay? There, the court was looking at the FSIA and the presidential provision, the EWSSA. And what we read there was the FSIA has a default waiver of Iraq's sovereign immunity. The EWSSA permits the president, quote, to make inapplicable with respect to Iraq any provision of law that applies to countries that have supported terrorism. The two are addressing exactly the same thing, and they're saying you can do one. The president can do one. So that was clear. We were trying to harmonize those two statutes and said, yes, the president has that power. Here, the way to harmonize the two statutes is to say it applies only to commercial exceptions permitted by the FSIA. And, as in Kurtz, or unlike as in Kurtz, the two statutes, if harmonized in that way, still make this operative.
Justice
Still
Sotomayor,
permits suits against foreign sovereign entities who engage in commercial activity.
that is a way to harmonize them. I don't think it is a plausible one. The other way to harmonize them
well, we go
is
back
by,
to what's plausible. Here
Well-
you have a suit that has survived a motion to dismiss. We know Western Union has business there. The suit is against an entity that's doing business with Western Union. There are ways, and there is money flowing into, even with the embargo, as extreme as it is at the moment, there are still many commercial investments going on in Cuba.
so Justice Sotomayor, again, the question we're looking at is 1996, when Congress codifies an extremely restrictive embargo in 6032H. It adds provisions preventing circumvention in 6040, and it allows extremely few exceptions for humanitarian links. And the question is, should the statute be read to allow causes of action only in the rare circumstances where they can find a connection to one of those humanitarian links? I think that is an implausible way to harmonize the statutes.
Thank you, counsel.